Paul has a criminal case coming up in May, and they finally got discovery. And they have 30 days to go to like 1,000 pages. So it was that was pretty hateful to do that. It's like an ambush. So I told Paul, what's your attorney's strategy? And he said, well, I think he just, in 30 days we're going to go to trial, and he's going to help me in court during trial. I said, why don't you do the old, federal rules of criminal procedure? Why don't you just do the old Rule 15? He says, what's that? I said, deposition. I said, either tell your attorney you want a deposition day at his law office, and that you want everybody who's going to be a witness to be summoned to appear. First, ask them, will they do it voluntarily? Because they're supposed to do it voluntarily. If they won't appear voluntarily, then you've got to get a motion in there, and I mean quick, to compel them to perform, to compel them to show up for the deposition. And what you want to do is it says, this is how they want to preserve the record to bring it into the court. So what you want to do is get that record from 1,000 pages to 2 pages. You want to destroy their warrant. You want to destroy their search warrant. You want to destroy their affidavits. You want to destroy everything. You want these witnesses to go over each page, 1 page at a time, and go through every damn thing and destroy every damn thing they said. This is going to be what you want to do. And you want to destroy everything that they're going to try to bring into the court. So that when you go to court, the other side only has 2 pages left out of 1,000. And you say to the judge, wow. The judge says, this case is going to be over in 20 minutes. Yep, that's all they got, those 2 pages. That's it. Other than that, I destroyed everything else during deposition. So they go, wow, okay, that's great. I said, or what the attorney's going to do is like, deposition, schmeposition. I don't need no damn depositions. I'm great. I know what the hell I'm doing. I taught Johnny Cochran everything he knows. I taught F. Lee Bailey everything he knows. I'm going to clean that clock. I'm the greatest attorney ever. His attorney might give you that crap, saying that he's the world's greatest. I said, what's going to happen when he goes to trial is going to be a few things he could do. He's going to say, Paul, you just write your list of questions, and when I get this clown on a witness stand, I'm going to destroy him. So what's going to happen is, Paul, your attorney's going to say, he gets the guy named, say the guy's name is Fred. He's going to put Fred on a witness stand, and you've finally been waiting a year to, bash Fred. And you're going to really tear into Fred, and you got a list of questions that you want to destroy Fred with. And your attorney's going to say, not right now, Paul, not right now, Paul, not yet, not yet, not yet. Just wait. I'm not going to object. No, just let Fred say, when it's our turn to talk, I'll clobber him. And then when it's his turn to talk, he's going to ask Fred, like a question, 1 question. And then he's going to say, I have no more questions at this time. And he gets stepped down. And you're going to go insane. You're going to say, why didn't you jump him? Why didn't you jump him? Say, we got plenty of time for that. We can call him back to the witness stand. Just watch my magic. I know what I'm doing. And then what's going to happen is the trial's going to be over, and none of your questions were asked. And since you didn't ask any of your questions, there's nothing appealable. And the attorney's going to say, well, we'll get them on appeal. And you're going to say, how can we get them on appeal? The judge didn't overrule or didn't allow us to. You never asked anything to be objected to or overruled. How are we going to appeal anything? Or your attorney's going to ask him every freaking question that you want. And he's going to maybe hook up with the other side. Or the other side's just going to say, maybe he doesn't even have to be unethical like that and hook up with the other side. Maybe the other side just is going to say, wait a second, where are we going with this? He's leading the witness. That's speculation. That's conjecture. This has nothing to do with what this man is on trial for. Well, this question is irrelevant. And the judge is going to say, sustained. The jury's to not acknowledge that question, just move along. And then he's going to ask a couple more questions, and the judge is going to say, look, I already warned you. No more questions. That doesn't have to pertain with the case. Not with the case that's at hand. This man is not on trial. The witness is not on trial. Your client is. So I said, either they're going to jump on your shit, and no matter what questions you wanted to ask him at trial, the judge is going to say, denied, overruled, da-da-da-da-da. And the attorney's just going to knuckle in and say, well, gee, I tried to ask you questions. Well, just ask him anyway. So that way I got something to appeal. It's like, nah, I don't want to piss the judge off. He's already pissed off as it is. I said, it's going to get stupid real quick. I said, so you need to deposition this guy. You need to deposition all the witnesses and take all the exhibits and all the evidence, and you need to destroy the case before it ever makes it into the courtroom. So I didn't get in touch with Paul today. I talked to him yesterday for quite a long time. And he said to me, Carl, will you come down to Tennessee if I get deposition day? I said, oh, absolutely. I'll make sure that attorney fucking behaves himself, that the attorney's actually depositioning these people, that he's actually giving them hard questions, and he's actually, working them over. So that's the time to do it, because you can't wait for the trial. And I told him, I said, look, if the attorney gives you any crap, I said, the judge appointed him, so the judge is liable for the appointment. So I said to him, thank God the judge appointed him, because if that attorney gives you any crap, he says he doesn't want to do a deposition day, you call up the judge's clerk immediately to his chambers, to his office, and you say, look, I'm entitled to Rule 15. I'm entitled to deposition the witnesses. I'm entitled to have all the evidence examined. And my attorney says he thinks that it's warrantless, or he thinks it's frivolous. I think it's mandatory. I believe it's going to be. I'll be able to save the court and some valuable resources, and cut this trial down, by 99% if I could just deposition the witnesses. And for some reason the attorney says, no, we'll make this be a week-long trial. Well, I'd rather deposition these witnesses for a week and then have the trial last 2 minutes. Why want to try to resolve all this, settle all this stuff in a deposition form? I want to try to knock out 99% of whatever we have in contention against the parties. This is what I want to do. Your boy won't allow it. So I said, that's how you're going to move. But that's how I would move if I was you. I said it's a legitimate rule, it's a legitimate tactic, and it's obviously it's supposed to be used to save the court room from being occupied for any real length of time. You want to knock everything out in the lawyer's offices, in the attorney's office. You don't want to spend a week in the courtroom. There's other people that could use that damn courtroom. Get 99% of it resolved in the lawyer's offices between the lawyers and the two parties. So when you walk in, the court will last 2 minutes, 20 minutes, we're done. Why? Because we resolved everything that we had, that was in contention.